In the UK we have over 11,000 laws that govern us, 90% of which are for petty offences. Each year around 70 new laws are thrown onto the stack. As it's impossible to know what all of these are, most of us rely on common sense and receive wisdom to stay on the right side of the law. But you might be surprised to find out that certain laws you've been abiding by don't even exist. So here are 5 things you think are illegal but aren't. Number 1. Trespass. Trespassers will be prosecuted signs are available from a multitude of online stores in the UK, but they're nothing more than empty threats because you can't prosecute a trespasser, not unless you're the Queen. Trespassing is not an offence in the UK. That includes trespass to parks, fields, farmland, building sites, car parks and your own front garden. If you find someone who has no legal authority to be on your property, then you can ask them to leave. You can even use reasonable force to eject them if they refuse to go. What you can't do is hold them captive and have the police intervene, because the only person likely to be arrested is you for assault. There are some exceptions to this trespassers cannot be prosecuted rule, but naturally they are mostly reserved for Crown and State, such as GCHQ and MOD, royal parks, royal grounds, public railways and airports. If you're caught trespassing on any of these, you could be arrested and charged. You can sue a trespasser in civil court, but the only way you could turn a civil trespass into a crime would be if the trespasser entered your land with the intention to intimidate, disrupt or obstruct lawful activity. This is known as aggravated trespass under the Criminal Justice and Public Order Act. The term activity isn't defined, but trying to remove someone from your land who shouldn't be there must surely be an activity. In which case, a trespasser refusing to leave when asked could be considered an aggravating factor. Therefore, what these signs should read is: Number 2. Resisting arrest. TV cop dialogue impresses upon us that any refusal to be dragged down to the station means you could be charged with resisting arrest. In America, this is a standalone offence. You can be tried and convicted of resisting arrest even if the arrest itself was unlawful. Not so in England, where resisting arrest isn't even an offence. Instead, we have assault with intent to resist arrest, which means you'd have to use some form of violence against your arrestor to be charged. We also have the offence of resisting or willfully obstructing a police officer in the execution of his duty, such as getting in the way of an arrest or interfering with police duties. The key phrase here is acting in the execution of his duty. Unlike in America, if a police officer attempts to unlawfully arrest you, you can use reasonable force to resist that arrest. This is because an unlawful arrest is not in the execution of a police officer's duties, and for added measure, you can sue them in the county court as well. Number 3. Lying to the police. If you're ever questioned by the police, they will happily give you the impression that if you lie to them, you'll be in big trouble, without actually telling you what that big trouble will be. That's because lying to the police isn't an offence. If it were, almost everyone who talks to them would be in jail. In extreme cases, you could be prosecuted for wasting police time or perverting the course of justice, such as Jeffrey Archer, who got 4 years for lying to a court over a decade earlier to win a £500,000 libel case. But simply telling the police something that isn't true is not an offence. It's only when you start making statutory declarations such as sworn statements, passport applications, job applications, and lying in court where the trouble starts, all of which are offences under the 1911 Perjury Act. But even if you did tell the police a lie of such epic proportions it helped you or someone else evade justice, you cannot be prosecuted for a lie that you genuinely believe to be true. A belief is not a lie, no matter how misinformed it turns out to be. Number 4. Underage drinking. Don't worry, I'm not about to tell you it's perfectly legal to give booze to 5-year-olds or something. Oh no, wait, that's exactly what I'm going to say, because it's true. The over 18 drinking laws you're so familiar with prohibit drinking in a public place or on licensed premises, not at home or any other private place where alcohol prohibition laws don't apply, and the only thing preventing you from serving booze to a child under 5 is your own moral decency and Section 5 of the Children and Young Persons Act. When you consider that Britain has the second highest regular intoxication rate of 13 to 16-year-olds in Europe, it makes you question the effectiveness of any of our drinking laws. The only country with a higher rate of drunk teens than our own is Denmark, who have identical drinking laws. What else do these two nations have in common that could explain our mutual obsession with drink?
Yay!
Number 5. Recording conversations. This next misunderstanding of the law is so commonplace it even has its own catchphrase.
We sometimes record calls for training and quality purposes.
Organisations must follow strict rules when recording conversations. You, on the other hand, don't. And you're free to record any call or face-to-face discussion without the knowledge or permission of the other party. And don't believe that myth of it being inadmissible as evidence if the other person has no idea they're being recorded. In English law, any evidence that is covertly or even illegally obtained may be admitted at the discretion of a judge. The bulk of our privacy laws are designed to protect the public from the abuse of government and private organisations, not the other way round. Companies are bound by strict telecommunication laws. The government are bound by the Human Rights Act, but all of them are bound by the Data Protection Act, which makes it an offence to process personal data for any other purpose than that which is authorised by statute. Under Section 7 of the Act, you're also entitled to a copy of any of your personal data an organisation stores and processes, including telephone recordings. All you need to supply them with is a written request, proof of ID and a £10 fee, and you can get a copy of your conversation if they recorded and kept it, thereby giving you the chance to listen again to how you were cut off mid-complaint by Virgin Media.